Mhm, mhm. Okay, it's 8 o'clock. So, for those of you who are here, thank you for logging on so promptly. I'm going to give it a couple more minutes to let anyone else join, and then I will get started. But thank you all so far for joining, and I appreciate it, and I'm excited for tonight's webinar. So just a couple more minutes to see if anyone else will also join us for tonight. Hello, everyone. For the sake of time, I'm going to get started. And hopefully, as we go along, more people will join. But I just want to say thank you, everyone, for taking time out of your Monday night to join us for this important and informative discussion. So, to get us started, this is AAPD's first policy webinar, and hopefully it'll be the first of many. Before we get into our discussion, I'll go ahead and introduce myself, and then also say a couple of housekeeping items, and then hand it off to our speakers. So my name is Rachita Singh. I use she, her pronouns, and I am the Senior Policy Associate at the American Association of People with Disabilities. For a quick visual description, I'm an Indian woman in my 30s with brown skin and dark brown hair, which is in a ponytail right now, and I'm wearing a cream-colored headband, a gray sweater, tortoise shell glasses, and pearl earrings. Now, our webinar today does include part captioning and an American Sign Language interpreter. We will also be recording the webinar as well and then posting it later. After I introduce our speakers, there will be about 40 minutes of a fireside chat style discussion, and then about 15 minutes of Q&A from the audience. So please, any questions that you do have, submit them through the Q&A feature, and use the chat only for technological concerns or questions in order to accommodate anyone using a screen reader. Now, as you all know, tonight's discussion is a dialogue regarding the intersection between reproductive rights and disability rights. So, of course, there's no better organization to help us guide that discussion than Planned Parenthood. So, our very own president and CEO, Maria Town, will be asking questions and providing the disability community's perspective. And from Planned Parenthood Federation of America, we have Callie Wells. Callie is the managing senior policy counsel working on state policy within the public policy, litigation, and law division at Planned Parenthood Federation of America. Callie has worked at PPFA since 2019, and before coming to Planned Parenthood, Callie was a healthcare associate at a law firm, and she has a JD MPH from Columbia University and a BS from Georgetown University. She grew up in Georgia, but has been in New York for over a decade. So thank you, Callie, and thank you for Maria for joining us tonight and for informing us. I'm really excited to learn more, and I'll turn it over to Maria to get us started.
Thank you so much, Rashta, and thank you for all of your work to put tonight's conversation together. For everyone's sake, my name is Maria Town. I serve as the president and CEO at the American Association of People with Disabilities. My pronouns are she, her, and hers, and for a visual description, I'm a white woman with long brown hair. I'm wearing a bright pink and floral print dress and bold lipstick. And Callie, I'll turn it over to you to do a brief introduction of yourself.
Wonderful. Thank you so much for having me. I'm genuinely super excited to talk through this with y'all. My name is Callie Wells. I use she, her pronouns. I'm the managing senior policy counsel at Planned Parenthood Federation of America. And for a visual description, I am a white woman with medium length wavy brown hair. I'm wearing a hunter green top, a black blazer, and blue plastic glasses.
Thank you so much for joining us tonight, Callie, and thanks to all of you who have joined us for tonight's discussion. There's a lot happening right now in the reproductive rights, reproductive justice space. And I just want to name, Callie, that we are so grateful for your time, as I'm sure y'all are fielding many, many requests. And it's actually one of the reasons that we wanted to have this webinar, so that we could make sure folks in the disability community had accurate information about what's happening right now across the nation when it comes to bodily autonomy, reproductive rights, and justice. So to kick us off with our questions, the Dobbs decision came out 2 years ago, and it held that the Constitution does not confer a right to abortion. And so the Dobbs decision returned power to the states to regulate any aspect of abortion, and we've seen in many, many states, lots of changes in access to reproductive health care. I'm from Louisiana. I, spent some time in both Texas and Georgia. My friends are really struggling to access the care that they need right now, whether it's prenatal checkups or things, questions around IVF. So can you go into further detail to give us a brief state of play on where we are regarding access to abortion and how things have progressed over the past couple of years?
Yeah, of course. In a lot of ways, it's crazy that it's been 2 years, but also so much has changed. So the important aspect of what you mentioned is that given we lost our federal protection, these decisions now all live with the states. And so every state is in a different battle. And within a year after Dobbs, we saw more than 40 lawsuits filed challenging abortion restrictions in 23 states. And just to give an idea of how long these cases are, about 22 of those remain pending either at the trial or appellate levels. So these cases are ongoing, and the abortion landscape in these states has shifted dramatically throughout the course of the litigation. Planned Parenthood is involved in many, but not all of these cases. And I'm proud to say that as a result of the litigation that my team has done, there is still some access or all access remaining to abortion in Arizona, Florida, Iowa, Ohio, and Utah. But as we all know, there are many bans that have gone into effect. So we predicted before Roe fell that if Roe were to fall, 25 states would be likely to ban abortion. And right now, 2 years after the Dobbs decision, we have 21 states that have eliminated some or all access to abortion. Bans have eliminated all abortion access in 14 states. Bans have eliminated abortion after the very earliest stages of pregnancy, before most people know they're pregnant, in 2 states, which is Georgia and South Carolina. Bans on abortion at 12 weeks are in effect in 2 states, North Carolina and Nebraska. And bans on abortion between 15 and 18 weeks are in effect in 3 states. So, as I mentioned, there are lawsuits ongoing in a lot of those states, and we are fighting against the restrictions, even if they are currently in place. But we at Planned Parenthood and the folks that are working in other groups that we work with, like the Center for Reproductive Rights or ACLU or Lawyering Project, and then the state groups that do this work as well, the goal isn't just to push back on bans or to hold the line with where we are right now. It's also to move the line forward where we're able to. So after Dobbs, a lot of our cases are in state court, where state constitutional protections is what we're fighting for. Essentially reestablishing the right to abortion under a state constitution instead of under the US federal constitution. So, and that has been successful in a number of states. We've seen successful ballot initiatives. So since the Dobbs decision came out, we've got 4 states that have passed proactive constitutional amendments to protect reproductive health care. That's California, Michigan, Vermont, and Ohio. And then in 2 states, the other 2 states where we've seen abortion on the ballot, it was actually a ballot initiative that would have been a defensive amendment. So it would have said, essentially, there is no right to abortion in our state constitution. Those 2 initiatives were defeated in Kentucky and in Kansas. So the stat that you'll hear a lot, which is great news, is every time abortion has been on the ballot since the Dobbs decision, abortion access has been the winning side of that vote. There are further efforts to put constitutional amendments in place regarding the right to abortion that we'll see on the 2024 ballots in a number of states. So that includes states like Arizona, Florida, Maryland, Montana, and Nevada. And some of those ballot initiatives will be legislatively referred. So they get to the ballot because they passed the state legislature, and others will be citizen petitions, which means they've gotten enough signatures from folks in the state to get that amendment put on the ballot. There is an effort in Colorado that would specifically repeal the state's ban on public funding for abortion and establish a right to an abortion going onto their ballot. And in 2024, we have an exciting ballot initiative in New York that is broader. It's an equality amendment. It explicitly includes protections against sex discrimination, which includes LGBTQ discrimination and access to reproductive health care. That New York amendment also adds protections against discrimination based on age, disability, or national origin. We're very hopeful about it doing well on the ballot this year, and other states are considering efforts for similar broad equality amendments, and those include Minnesota, Oregon, and Connecticut. So in total right now, where that leaves us with proactive protections is that there are 14 states that have constitutional protections for abortion, and there are 18 states that have protections that live in their state statute. So while that we still consider that a state that has a protection on the books, it's not as strong as a constitutional protection, because statutory law can be changed with different legislatures and can be interpreted in a less friendly way by the state courts. So right now we have 26 states total with some protection in their law, either constitutional amendments or statutory protections. And when we think about where we are, overall, we have reasons to be hopeful. We do see positive results on ballot initiatives. We have established constitutional protections under multiple state constitutions where they didn't exist before. But we also see that this onslaught continues. The movement that is fighting to limit rights to sexual and reproductive health has no intention of stopping now that, they have overturned Roe. That's not the end game for them. We see that in the creative and potentially destructive cases that we have this year at the Supreme Court. I know we're going to talk more about those later. But we also see it in sort of the way that they've expanded their attacks. We see attacks now on IVF, on birth control, and though I don't consider, and we don't consider at Planned Parenthood this a form of sexual and reproductive health, it feels remiss not to mention that it is very related to the attacks we're seeing on gender affirming care. They're politically motivated attacks. They start with the most vulnerable individuals in both cases for abortion and in gender affirming care context. That means minors. And it really is a way to rally a base and get high voter turnout on issues that voters misunderstand or don't relate to. And we have seen a massive proliferation of attacks on gender affirming care in a way that I think has really shocked and overwhelmed advocates. We've gone from no states banning gender affirming care for minors in the year 2020 to 1 in 2021, 1 more in 2022. And by now we have 26 states that are banning best practice medication and surgical care for transgender youth. A few of those are enjoined and are not in effect, but still the fact that the abortion map and the gender affirming care ban map for minors already look so much like each other is really clear evidence that these are specifically aligned attacks that are coming from the same side and with the same goals.
Callie, I'm really glad you mentioned that, and I'll just note for everyone's awareness that people with disabilities are more likely to identify as LGBTQ, and people with disabilities are also more likely to be trans. Autistic youth especially have a much higher likelihood of being trans themselves, and I believe it's in Georgia in one of the proposed bills around banning gender affirming care had this specific mention of autism in it. So there's a real disability component to these bans on gender affirming care as well. And I will also add that the map on voting restrictions, which is very important to AAPD, is also very similar to the maps on abortion restrictions and gender affirming care restrictions.
Yeah, we've seen in Missouri, for example, there was a bill that would impact gender affirming care even for adults. It actually started as an AG opinion and then was put in legislative form, and it didn't pass. It's not in effect right now, but it would have essentially required that a provider sign off that every comorbidity that was mental health related was cured before somebody could access gender affirming care, as if number one, that's possible, and number two, as if being trans is a mental health disorder and or is just associated with other mental health disorders. So it is a targeted attack, and they know that they're going after the most vulnerable communities.
So one of our goals tonight, and I think that this response has really demonstrated this, is to show how intersectional these issues are. And bodily autonomy specifically is not new nor unfamiliar for the disability community. In fact, bodily autonomy is a core principle of the disability rights movement. Historically, disabled people have been denied the opportunity to decide what happens to our bodies. And some of the most poignant examples of this are forced institutionalization and forced sterilization. And just today, the FDA has announced a plan to ban shock devices that are used on children with disabilities in a residential school. So there's lots tied up in disability rights and bodily autonomy. What does bodily autonomy mean when it comes to reproductive rights and reproductive justice? And how do you believe this impacts underserved, multiply marginalized, or vulnerable communities, including people with disabilities?
Yeah, it's a good question, and it looks different from different frameworks. So Planned Parenthood specifically is a reproductive rights organization. So what we think of as bodily autonomy is we think of it from a reproductive rights framework. And what that means is that everyone should have access to the healthcare they need to make their own decisions about whether and when to have children. It includes decisions about pregnancy, birth, contraception, fertility care, abortion, the gamut of what you would consider sexual and reproductive health care related to when and how and if to have children. The reproductive justice framework that many of our coalition partners operate within is broader. It considers whether people have the right to parent in safe and healthy environments. And obviously that is very influenced by things like systemic racism, sexism, and ableism. So the reproductive justice movement was started by Black women who recognize that even when care is legal and you have the right to access healthcare, it can still be largely inaccessible, and that most often is concentrated on certain populations. And we all know this to be true. Even now, it's very clear that those who have always faced more barriers to accessing healthcare are the ones who are being most affections and bans that we've seen passed on abortion. And that includes people of color, LGBTQ individuals that we talked about, and people with disabilities. So reproductive rights and justice issues are very clearly intertwined. There's a lot of overlap and intersectionality there. There's and that includes both with repro rights justice and with the disability rights community. So those with disabilities have always faced discrimination, including in healthcare. And now that access to reproductive health care is so much more limited, we know that it can be next to impossible for people with disabilities to access the care that they need. We know, for example, that these recent attacks on IVF in Alabama specifically impact those with disabilities, given how specific and tailored assisted reproductive technology needs to be for people with disabilities. And we know that right now people are being forced to travel long distances to access abortion or miscarriage care. And that can be virtually impossible to folks with disabilities or just much more challenging. We also know that telehealth care has been kind of seen as the solution for a lot of people who may have trouble traveling. And while that might be true for some folks with disabilities, it might not always be appropriate or tailored or accessible to others with disabilities. So when we think about this at Planned Parenthood, we know that there's been work to do even before Dobbs in terms of eliminating discrimination in healthcare and expanding access to reproductive healthcare and to sex ed for people with disabilities. That includes at our centers. We know that politicians have created a lot of the barriers that we see to care, but we also know that there are big issues at the provider level as well. And we know that there's a lack of reproductive healthcare education and training for providers who work directly with disabled patients. So we've seen some progress for sure. I think especially post-Dobbs, groups have been giving each other grace in like a really lovely way. And we've seen progress in collaboration between repro and disability communities. For example, on the advocacy side, the Center for American Progress runs a federal coalition group where some great materials and conversations have come out of that group. And we've seen several panels every year now at the annual NAF conference that is for providers, really digging into this intersection and the need for better collaboration and improvement of relationships. But we do know that is a lot more that we should be doing and that this collaboration needs to continue and to grow. And it's one of the reasons that I'm really, really honored and happy to be here talking with you all tonight.
Yeah, thanks so much, Callie. And AAPD is a part of the coalition that the Center for American Progress runs. And, I'll just add that a huge part of the reason that there continue to be these gaps in access to care is because of assumptions and societal prejudices around what's possible for disabled people, right? So the assumption that we either don't have sex or don't engage in romantic relationships, or will not need any kind of reproductive care, and that is, patently not true. And I think the other piece that has contributed to many of these gaps in knowledge and gaps in accessible treatment is the idea that disabled people actually only engage in sex, for example, when we are victims of sexual violence. And while disabled people are more likely to experience sexual violence, this cannot be the only way that we discuss people with disabilities and sexuality and needing reproductive health care. So I will also add as an advocacy plug, I hope that everyone on this call is watching the federal regulatory space, because at AAPD we are hopeful that the Biden administration will finish the Section 504 disability non-discrimination in healthcare rule, which will require healthcare providers to have things like accessible examination tables and other accessible diagnostic medical equipment. And it is my hope that that will spur more clinics like Planned Parenthood clinics having, accessible scales so people can get weighed and things like that. So other reasons to be optimistic right now. So tomorrow, the Supreme Court will be hearing the oral arguments for the Alliance for Hippocratic Medicine versus the Federal Drug Administration case, which centers on the pregnancy-related medication mifepristone. Can you briefly describe the details of this case, why it's important, and its potential consequences? And at AAPD, we've done a lot of work to help maintain access to mifepristone and other drugs as all of these legal proceedings have happened. We've worked with Health and Human Services to try to make sure mifepristone continues to be available for anyone who needs it, including people who need it for pregnancy-related needs, but also people with conditions like rheumatoid arthritis or other cancers that use mifepristone as a form of treatment and management. So, Callie, I'll pass it over to you.
Yeah, it's hard to explain this case briefly because it's complicated and weird, I'll just say. But the upfront most important headlines here are that this is a politically motivated case that aims to remove mifepristone from the market. Mifepristone is one of 2 drugs that is used as the standard course of treatment for a medication abortion. It is an incredibly safe medication. It is very effective. It has been used by more than 5 million people. It's been approved in the US for over 20 years. So this doesn't stem from concern about the safety or the science. This is really just an attack on abortion access. So to back up and give some history about what the case is, towards the end of 2022, there were several anti-abortion medical groups that seemed to be formed out of nowhere in Texas that brought this suit. They're represented by the Alliance Defending Freedom. The lawsuit was filed in the Northern District of Texas, seeking to block the FDA's year 2000 drug approval for mifepristone. And block all subsequent FDA decisions making changes to the FDA's regulations on mifepristone, essentially to remove mifepristone from the market. The plaintiffs sought a preliminary injunction that would invalidate the FDA's approval and would make it unlawful to provide medication abortion in the form of mifepristone across the country. There were several procedural hurdles to this case from the very beginning, including the fact that the plaintiffs really don't have any legal injury, which is typically a requirement for a lawsuit to be brought, and that many of their claims have been filed years after the statutory limitation on bringing such a claim would have passed. But the plaintiffs purposely formed and then filed this case in Amarillo, Texas, where there was one specific federal judge in this district, Matthew Kaczmarek, who was appointed to the bench by President Trump and who is presiding over multiple anti-abortion lawsuits right now. So it was very specific where they filed it and why they brought this case, when and where they did. So since they brought the case at the end of 2022, there have been a number of decisions along the way. I won't get into the details of all of those decisions, but one important decision to highlight is that in April of 2023, the Supreme Court of the United States granted what we call a stay that was requested by the Department of Justice and by one of the mifepristone manufacturers. And that stay has allowed mifepristone's FDA approval to remain unchanged as this case proceeds. So because of that, mifepristone has remained approved and available in the same way that it was before this case was filed throughout the course of the lawsuit. So if people are worried that mifepristone isn't available right now or might not be available after the oral argument, that type of thing isn't going to happen. The next time that we could see a change in the status of mifepristone will be when the Supreme Court ruling comes out, likely in June. So to talk very quickly about what the Supreme Court is actually considering, the last major ruling in this case came from the Fifth Circuit Court of Appeals in August of 2023. And that court essentially came out with a holding that said the FDA's approval of mifepristone should be rolled back to where it was in 2016. And that means anything about the FDA's action since 2016 would be invalidated, and we would go back to a place where the drug should be used in the same way that it was in 2016. That would be a very complicated and confusing decision for manufacturers or providers to try to implement, due in large part to the fact that mifepristone is regulated under a very complex structure under the FDA that's called the Risk Evaluation and Mitigation Strategies Protocol. You might have heard that discussed as the REMS. Mifepristone is subject to the REMS. Again, we don't need to get into tons of detail about what that is, but essentially it means that the REMS are typically applied to more dangerous medications, but it has been inappropriately applied to mifepristone ever since mifepristone was first approved in year 2000. And the REMS is the reason that mifepristone is not a drug that for decades providers could just write you a prescription for and you could go to your pharmacy and pick it up. Instead, under the REMS, there's an in-person dispensing requirement. And that means that the provider needs to give you the pill in person. The FDA got rid of that restriction during COVID and since COVID. But if we think about the Fifth Circuit's ruling, that is one of the things that would have to come back into place if we rolled back the clock to 2016. So to be clear, that ruling and others that we've seen in this case so far ignore science, ignore the law. They undermine decades of research and the FDA's scientific judgment in improving medication. And we have seen throughout this case the politically motivated nature of the case in the form of its rulings as well. So now we're at the Supreme Court. The Fifth Circuit decision came out, like I said, in August of 2023, and the Supreme Court decided to hear the case, which they call granting cert, in December of 2023, meaning that's why we're having oral arguments at the Supreme Court tomorrow. The specific questions that the court is going to consider tomorrow is, number one, whether the Fifth Circuit Court of Appeals erred in finding that the group of anti-abortion doctors who brought this case and who do not provide or prescribe mifepristone had standing to sue, which we think they don't. We don't think that they are valid parties to bring a case like this. And whether the Fifth Circuit Court of Appeals erred when they upheld the preliminary injunction of the FDA's 2016 and 2021 actions that expanded access to mifepristone. So essentially, whether it was improper for them to roll back the clock to 2016. So the case's repercussions do go way beyond abortion care. This really could stifle medical innovation. It really disturbs the concept of what we think of as the way that we approve drugs in our country, the way that drugs are controlled and monitored. If our court system is now ultimately the place where we're deciding what drugs are available to people and how, we'll end up with a Supreme Court opinion, like I said, likely in June. We would consider it a win if the Supreme Court found that these providers lack standing, or if the Fifth Circuit erred and mifepristone remains on the market in the same way that it is now. But there are also potential loss scenarios where access to mifepristone becomes more restricted. And we think it's unlikely that we will see a scenario in which mifepristone is fully removed from the market after this decision, mostly because of the questions that the Supreme Court took the case based on. They didn't take a question that is quite so broad. So while it is potentially possible that the Supreme Court would remove the FDA approval altogether, we think that's pretty unlikely given the questions that they're going to answer. So again, a win, things remain as they are now, and potential loss is we do see more restrictions on access to mifepristone, both for medication abortion and, like you mentioned, for any other purpose that somebody might need that drug for.
And you got at this, but one of the biggest concerns that we have, that I think many in the disability community have, is if the FDA's authority around mifepristone is eroded, what will this mean for other drugs and medications used to treat all kinds of conditions and disabilities? And one of the things that I have taken away from the past 2 years is any condition can become politicized. So, today it's having excuse me, needing to take mifepristone for medication abortion, and tomorrow it could be related to mental health, or, you know, this further stigmatization of depression or bipolar disorder. And, you know, we're not going to allow those medications out on the market. Anyway, I'm not going to let
Totally.
myself go down that path too far. And I want to get into to our next and kind of final set of questions before we open it up to questions from the group. And we've gotten a couple of really good ones. So people with disabilities are more likely to experience high-risk pregnancies and experience complications during their pregnancies and during their birthing experiences. People with disabilities are more likely to experience blood clotting, hemorrhaging, and infection during pregnancy. We're significantly higher risk of dying for pregnancy and childbirth. And disabled people, especially disabled people of color, often experience prejudice and discrimination within healthcare settings, as we've already discussed. And this includes prenatal care. And all of that can contribute to the ever worsening maternal health crisis. So from your perspective, what does access to prenatal care and safe and healthy childbirthing look like? And what are the barriers to access?
Yeah, I'll try to be brief because I know that you have a few other questions that we want to get through. But I think ideally, any pregnant person would have routine monitoring by a trusted provider during pregnancy that and would have access to whatever medical support they choose during their birthing process. Ideally, that provider has specific knowledge and understanding and appropriate training to tailor their advice and care to the patient's specific needs. We know there are a lot of systemic barriers to that becoming a reality for most people. To accessing healthcare broadly, of course, including but not limited to prenatal care. During pregnancy, there are issues like lacking insurance coverage or cost prohibitive out-of-pocket fee structures for routine prenatal care. There are people that avoid birthing in healthcare centers because of the potential cost of doing so. There are also really poor provider networks in a lot of places in our country. And that's one thing that I think has worsened absolutely as we've seen these bans on access to abortion. When you think about the providers in a lot of communities that are providing OBGYN services, oftentimes those people do want to be able to train and provide the full scope of what they consider to be sexual and reproductive health. And so sometimes they're now moving to other places where they can continue to provide that care, and they're leaving a care desert behind where people not only can't access abortion in banned states, but they also then lose the other services that those providers would have provided, including things like prenatal care and birth support. So we see poor provider networks, like I mentioned, and then there are other major issues for people accessing the healthcare network around bias and racism, especially for Black women. There is a very real and warranted distrust of the healthcare community and system during birth for people of color in our country. And for people with disabilities, there are specific barriers to access that, of course, y'all know better than I do. I don't purport to be an expert in care for people with disabilities, but those being, or certain issues being undiagnosed lead to more complications in pregnancy. And that's much more likely to happen with people with disabilities because providers, as we've already talked about here, aren't as likely to trust or listen or ask questions to a lot of people with disabilities. And that includes lacking accessibility, both to physical spaces or to virtual care spaces in a lot of places in our country. And yeah, all of these things really combine in a very negative and sad way to put care out of reach of a lot of people that need it in our country for various reasons.
So the next thing that I wanted to ask you about is another Supreme Court case. This one is upcoming, and it is in regards to the Emergency Medical Treatment and Labor Act, or EMTALA. So what impact could the EMTALA case have on access to abortion?
Sure. So as I mentioned, this, when we think about this in conjunction with the mifepristone case that's being heard,
Mhm.
we really see a trend here. There are other cases ongoing as well that we won't have time to talk about tonight, but there is a cohort of very specific cases that are running through our court system that could limit access to abortion. So we're seeing every lever of government being pulled to try to limit and restrict access to abortion. This particular case, the EMTALA, as we call it, is the Emergency Medical Treatment and Labor Act, as you mentioned. It is a well-established, long-standing federal law ensuring people that are in medical emergencies get the care that they need in hospital emergency rooms. It's a really specific law. It's been in place since, I believe, the 1980s, although I don't have the exact date in front of me, but it's been in place for decades, and it exists even after Dobbs. And it makes sure that hospitals offer emergency services if they receive Medicare funding, which hospitals mostly do in our country, and emergency care to all patients, regardless of their ability to pay. It was initially enacted because of the fear that hospitals would sort of what they call patient dump and try to get rid of patients that couldn't pay their bills. And it wanted to make sure that no hospital was ever turning away somebody that was in an emergency care situation. So it sounds obviously like it should be uncontroversial, but now there are questions about what hospital emergency rooms do, or hospitals with emergency rooms, I'm sorry, do when people are experiencing an emergency, and the best course of action for that person to resolve the emergency is to give that person an abortion, especially if they are in a banned state. So this case is now going to appear in front of the U.S. Supreme Court. They'll hear in the oral arguments in April, and the case is called Idaho versus the United States. It was actually initiated by the Biden administration, and there, the Justice Department filed this lawsuit in August of 2022, claiming that the state's abortion ban actually violated EMTALA, this federal law, because the ban only made exceptions for abortions that were necessary to prevent the death of the pregnant woman. And the Biden administration argued in this case that there are instances where somebody needs emergency care, even if they're not dying. They might have severe bodily injury or things like that, real significant harm in the form of things like hemorrhage or ectopic pregnancies that are quite dangerous, and you can lose your fertility ongoing from things like that. And so the federal law, essentially, they claim as being violated by a state that only allows abortion to prevent the death of the pregnant person. So that's what the Supreme Court is going to decide, is whether or not this federal law, EMTALA, preempts state laws that ban abortion, such as Idaho's existing ban that's currently in effect. And if the Supreme Court doesn't reject this effort and allows states to ban abortion, despite there being really significant emergency situations, that's really devastating for anyone who can become pregnant. People, obviously, in our country, the bare minimum is that we would be able to get the emergency care that we need, including if we're a pregnant person and we need access to abortion. So we're seeing very clearly in this case that anti-abortion lawmakers are willing to endanger pregnant people, even in emergency situations, to prevent abortion. And we know what happens in these cases. We see it already in Catholic hospitals sometimes. And there really are stories of people that have gotten very close to dying before they've been able to get the abortion care that they need, because certain Catholic hospitals have policies that require that the patient get to that point before they will receive the care they need. And in some places, that people aren't even getting the referrals that they need. And obviously, we don't have to imagine who gets most harmed by these policies. It's the same thing that we've been talking about over and over again. The people that end up being most harmed are people that are systemically discriminated against in our healthcare system. So yeah, it's scary to think about a world in which our federal law does not even protect pregnant people in medical emergencies, but that's the question that we're going to hear the Supreme Court consider.
Thank you so much, Callie. I want to open it to questions from our participants. We've already gotten a few.
Sure.
The first question that we received, which I think was connected to your first response, is what about the recent protections that Oregon signed into law that was driven by Planned Parenthood working with several groups in Oregon?
So I haven't worked specifically on the law in Oregon, but Oregon has been really great in terms of codifying proactive protections. For example, Oregon is the first state in the country to not only ensure that under Medicaid abortion is covered, but also ensure that undocumented immigrants have access to Medicaid coverage for abortion in their state out of a separate state fund. So there have been really great efforts in Oregon to make sure that not only is care legal, but it's fully accessible. And we know there's a big difference there. And we also know how important Medicaid coverage is for so many people in our country. And specifically for people with disabilities, they're much more likely to be on Medicaid recipients. And so those are wonderful efforts. I'm not sure specifically what law the person who asked the question wanted to talk about, but I'm happy to always pull information or give citations in an email if there's specific follow-up that anyone has about that.
Great, thank you so much. A second question asks, what other types of reproductive health care or medications could have could be negatively impacted by a potential negative ruling on the mifepristone case?
Yeah, so that case is very specific to Mifeprex, is the FDA approved brand name version of mifepristone. But as we mentioned, the real kind of fear here is that we lose control over the way our FDA regulates medications writ large. And we've seen some states that have essentially created what we consider to be mini FDAs, miniature, I guess, FDAs because I realize that people can't read that word, MINI, at the state level. So what those states have tried to do is make any manufacturer or distributor of mifepristone register at the state level and meet very specific reporting requirements. And what those states have done is actually apply that restriction more broadly to any drug that could induce an abortion. And that has been really scary because there are a lot of drugs that ostensibly someone could think could induce an abortion and that are used for other really vital healthcare treatment functions that would fall under the regulations of these state laws. And for the most part, we haven't seen those bills proliferate, but we don't want to get to a place where the federal FDA loses control over drug access in our country. We know that there are nefarious states that would use that type of privilege to restrict access, not just to mifepristone, but to any other medication that they have moral qualms about for some reason. And you've talked some about drugs that we use to treat mental health disorders. There are certainly other drugs that they could associate with potentially ending the life of a fetus. I mean, there are acne medications that have devastating effects on fetuses. So if you gave the states the power to restrict or ban any drug that they think could cause moral harm, that could have really far-reaching implications. And when you think about the fact that this isn't even necessarily a state trying to do this, this is federal court system, that introduces just another player into this world where previously the FDA has been led by scientists and peer-reviewed long, extensive research trials. And this is not a world in which we have political decisions being made about what drugs we think are moral or good. This is about safety and efficacy. And so we really don't want to lose that being the driving force behind our medication access in this country. So I guess the short answer to the question is this case that we're hearing right now is really just about mifepristone, but it could have really potentially damaging and problematic consequences to other drugs.
Yeah, thank you for that. And the questioner on Oregon says that the Oregon law was HB 2002, which established broad rights of individuals to make decisions about their own reproductive health care, use of contraception, abortion, and gender-affirming care.
Yeah, it is a good bill, actually. I'm sorry I didn't recall that specific bill for the first question, but that is one of the bills that was actually highlighted this session as being one of the best proactive protections for gender affirming care that we've seen a state pass, including things like insurance coverage for gender affirming care as well, that sort of mirrors what the state was already requiring for insurance coverage for abortion. So thanks for highlighting it. It is really genuinely a good model piece of legislation.
Thank you. So the next item we have is actually a comment, and this person says PBS just showed a documentary called The Eugenics Crusade. It had a clip of Margaret Sanger saying that people with epilepsy, people with intellectual or mental health disabilities should not be allowed to have children, and went on to say she was a part of passing laws on the forced sterilization of people with disabilities that still exist in 26 states. She was the founder of Planned Parenthood. Even now, Planned Parenthood only promotes the right to abortion for parents who may birth disabled kids. If you don't mind, Callie, I want to speak to this, and then I'll pass it to you if that's okay.
Yeah, for sure.
And I'm really glad that someone brought this up, because one of the things that's happened, it was happening before Dobbs, but I think it has happened even more so since the Dobbs decision came out, is that there's been a lot of work with organizations like Planned Parenthood and others in the reproductive rights space and disability community organizations to inform things like talking points around abortion. I can't tell you how many times I've said, like, we have to have other storytellers out there who are not just talking about getting a prenatal testing result and making a decision around abortion after that. The dynamic that this person is speaking to is actually one of the reasons why AAPD did not have a position on abortion until Dobbs happened. And our position today is that all people, especially people with disabilities, should be able to decide what happens with their bodies. And this issue of selective abortion is of major concern, but the way that we address that is not through restrictions on access to healthcare, but in addressing the larger systems and prejudices that go into why parents make that decision. And I also know, Callie, you mentioned in your opening remarks, actually, some of the things that you all are doing to better serve actual disabled people as patients and participants in your program. And so is there anything more you want to say on this?
Yeah, I'll say, obviously, Margaret Sanger wildly predates my time at Planned Parenthood and anyone that's currently at Planned Parenthood's time here. But there has been very purposeful communication from Planned Parenthood to clarify that the organization does not stand with the views that Margaret Sanger founded the organization upon when the organization was founded, essentially. Those views we now see and view and discuss as discriminatory and extremely problematic. And I'm not in our communications department. I don't represent PPFA as a whole, but there are statements available online if anyone is curious sort of what the current Planned Parenthood position is on those issues. In terms of the access to abortion for parents, I think we have seen the disability community be used as a tool by politicians who seemingly engage none with proactive disability policy as an excuse to ban abortion. So what I mean by that is in states where what we'd called reason bans would be introduced, politicians that support those and talk about them as being a way of supporting the disability community would not have any other legislation that was ever introduced that actually proactively supported the disability community, nor would they engage with the disability community about those bills. So we know they came from a place of wanting to ban abortion, not wanting to support the disability community. And I certainly cannot say that Planned Parenthood has been perfect in this regard. In fact, I'm certain that we have not been. But I do think that at least since I have been here, anytime that we have engaged on those bills, we have made very clear that the disability community should be leading any efforts to talk about those bills and the policy around them, and using messaging from other groups, and also making clear that people deserve the right to information and the right to make the decision for themselves. And that the state shouldn't be making that decision for any individual who is pregnant or considering their pregnancy outcomes. Yeah.
Thank you. So we have two more questions, which I think is all we have time for. And I'm going to ask one, which I think is a little, the answer is a little shorter first. One person asks, what are the 4 states that passed proactive constitutional amendments? California, Vermont, and which other ones?
Michigan. And let me look at my list because it's hard for me to recall them that quickly. Ohio.
So California, Vermont, Michigan, and Ohio are the states with proactive constitutional amendments
that have passed since Dobbs. Yes,
that have passed since Dobbs. Good qualifier. And then this may be our last question. Maybe we'll have time for one more. This person writes, hello, I'm a disabled family medicine resident in Virginia and former APD intern. So thank you for joining this call, APD alum. And I am curious about the best way I can use my voice to advocate for reproductive rights and gender affirming care. I'm also curious about resources I can provide for my patients. Thank you.
I think this is a great question. I think it is one that we get a lot. And I also think people are sometimes dissatisfied with the answer because there isn't a silver bullet for folks who care to fix this problem. There are a lot of people who have been working on this for decades, and we seem to sometimes be losing, which is a bummer, but we're continuing to work, of course. But I would say for someone who, especially from a provider lens, if you're comfortable with advocacy, trying to educate people where possible, not only on the importance of sexual and reproductive health care specifically, but on the specific ways that losing access to care impact your patients or impact folks with disabilities or impact very specific populations or people you know. We know that people respond more and get engaged more to threats and to their rights when they either feel them directly or they understand the direct impact on people they know and trust. And so if you're able to do education just in your own community and to your peers or to your patients, that kind of stuff is meaningful. And then I'll say, this is probably a bit of a shameless plug because I do state policy, but this is happening at the state level at this point. And there is so little involvement or awareness in state and local politics in our country. And even a very small amount really can move the needle. A lot of times these bills are passing with no one paying attention. There's no one testifying. There's not many people calling their legislators or writing to them. And we really do see legislators moved by what we would consider a relatively small amount of community engagement. So if you have the time to kind of pay attention to what's going on in your state and local elections and legislation and policy, and if you have the ability even more so to reach out to legislators to testify at your state house, if that's accessible to you, those types of things genuinely make a difference. These legislators kind of are realizing that these policies aren't especially popular. And a lot of times they really want to pass them sort of in the darkness of night. They want to pass them without much fanfare at this point. We're seeing governors sign these bills without doing press conferences, for example. And so if we can make them feel like people are paying attention and really care and want to engage, it can actually really make a difference. And so, yeah, I mean, those are the things that I think people can do. For provider specific resources, I'll try to look at that and send an email. We obviously at PPFA have our own internal guidance that we provide to our providers, and there are a lot of resources that are shared amongst the Planned Parenthood network. So I'm not as familiar with who is generating good trainings. Obviously NAF is a big one for us, but there are certainly others. And so I'll try to do some hunting and send an email to Maria with good resources for providers who are allies and want to advocate and for their patients in terms of access to abortion and gender affirming care.
Thank you so much, Callie. And one thing I'll say too, especially on the gender affirming care piece, is for people with disabilities, particularly folks with intellectual or developmental disabilities, someone who is gender nonconforming or trans, that identity may be read as a behavior instead of an identity. So you might see things like an IEP read, you know, Maria needs to understand that blue is for boys when, you know, the student is actually a trans student who wants to present themselves differently in their classrooms. And so I think as a provider, actually being open with your patients about what's possible and respecting them and listening to them is just such an incredible baseline, which I'm sure you already do given given your work. But I just have to reiterate that myself, especially as someone who has just been repeatedly dismissed and not listened to by medical professionals. So even that alone, I think, is a really great place to start. And we can't underestimate the value of basic dignity and respect of disabled people in medical settings. So, Callie, we are right at 9 o'clock. We have gotten through all of our questions. Thank you so much for your time. There was one other question. Folks asked if there would be a transcript of this call. So we are going to post the recording and transcript on AAPD's YouTube channel, and we'll be sure to email everyone who registered for this call with those resources once they are posted. So Callie, thank you again for your time, and Rashta, thank you for your work to arrange this chat.
Thank you all so much for having me.
Thank you. Thank you everyone for joining us. And thank you, Callie and Maria.
And thank you to our ASL interpreter and our CART transcriptionist.
Yes.
Absolutely.
And I hope everyone has a great night.
Good night, all.
Thank you.